Welcome to Lawctopus Law School's free and open webinar on how to research for a Moot memorial. As you all already know, mooting is an essential part of the entire law school experience, and understanding this art can definitely take you places. As we all already know, the first step towards becoming a good mooter is to learn how to research in order for you to make a memorial. And to help you understand this process a little better, and to just simplify this process for you, today we have with us Mr. Sambhav Sharma. He is a fifth-year student at Amity Law School Delhi, IP University, and he is currently the convener of their Moot Court Society. So Sambhav has participated in a number of national and international moots and has won several of them as well, including the Jessup Moot Court competition. He was also there in the Willem C. Wiss East International Commercial Arbitration Moot Court competition of 2020. His team was also awarded 2 honorable mentions for Best Memoranda in the 4th AIAC Wiz Pre-Moot 2020 at Malaysia. And he currently serves as the associate editor and India correspondent at Juris Legal News and Commentary, which is based in the University of Pittsburgh in the US. Thank you so much, Sambhav, for being here. We're absolutely ecstatic to have you here, and we're looking forward to learning a lot from you today, to a very, very amazing session.
Thank you so much. Thank you for that generous introduction.
So Sambhav, let's start with the first question. How do we start with the process of researching?
Right. I think once anybody has selected a moot, the first thing that they receive along with the rules is the moot problem itself, right? And that's, I think, the beginning or the initiation of your mooting journey, as we call it. So analyzing and understanding the moot problem, Savarna, I feel is absolutely crucial. And I understand that, to some it sounds very elementary that, of course, everybody reads a moot problem. But the way in which a moot problem is approached or tackled is something that I feel can make a huge difference. So I will share the way in which I have personally over the years started reading moot problems. One mistake that a lot of young mooters make is that they read the moot problem once, and without understanding the nuances of the facts, they immediately turn to researching because they feel that moot problem is only facts, and what is required is the research on law. While that's researching on law definitely is a huge part of mooting, but I feel that understanding and comprehending the moot problem is absolutely crucial and could in fact be dependent on whether you're winning or not, right? So reading the moot problem essentially means that for the first 5 odd days, you just sit with the moot problem, either a printout if you're comfortable with that, or on a screen, and just scroll through the moot problem, read every single sentence, every paragraph, and highlight the pointers that you feel could be crucial. Because when you read the moot problem once, you're reading it from a fresh perspective. But when you keep reading it again and again and again, you understand that there are certain details of which you probably would have missed out on initially. So reading the moot problem thoroughly for at least 5 to 6 times, you don't need to memorize it, of course. You will eventually memorize it naturally when you keep researching on that. But reading is very important. And once you read it, what I do is I keep making certain documents side by side. Right? So a list of dates is a very important document that one should make while reading a moot problem. Because what happens is a lot of the facts or a lot of the contingencies or the problems in the moot problem are based on the happening of certain events, right? See, for example, if you take a problem of a contract law, now you would not know when the limitation period expired of the contract if you don't know when the contract was entered into or when the breach occurred. So making a list of dates and events is very important, because then you won't have to keep going back and searching the dates in the paragraphs, and you have like a concise list of dates available. So do that in the first initial readings. Similarly, you should also make a list of personalities and entities, because oftentimes what happens is a lot of moot problems have very complicated names or characters, right? Mr. XYZ and so, which turn out to be quite important to the moot problem. Also, because if you do not know who the personalities and entities are, eventually in your oral rounds, when you have to address to them as either your clients or the opposition, it becomes equally difficult for you to, go on naturally with the moot problem or with the oral arguments. So making a list of dates and list of events and also a list of personalities and entities, different organizations and what role they play, I feel has helped me out a lot, because eventually, when you find more about certain entities, you can just go back to the list and then see, okay, these are the small notes that I made. Other than that, I just feel that while researching, you should also start, forming arguments in your mind while reading the moot problem. Which means that, say, for example, if you're representing the petitioner in a moot problem, in a moot, or a respondent, or maybe you're representing both the sides, because that's what happens usually in moots. What you should do is you should keep culling out certain points. Okay, this is a point that might favor the petitioner or the applicant, and this is a point that might favor the respondent. Because once you've done that, it's just easier to come back, and it's always better to color code. So, say for example, green or blue is something that I use for applicants or petitioners, and red I use for respondents. So just highlight the moot problem, so that when you come back, okay, this is exactly where I have to go to get back to this fact. So while reading the moot problem feels very elementary, but I feel that to start off the research for a moot, you should always begin with reading the moot problem and making these certain pointers, these certain documents, which will always come handy when you eventually start researching on the law. So that's, I think, a way in which I would start.
Thank you so much, Sambhav. So Sambhav, how do we approach conducting a preliminary research on applicable law?
Right. So I think once you're done with, it's in fact a good follow-up question, because once you're done with reading the moot problem, understanding the very essence of, what the dispute is, because everything arises from moot problem, right? Then we go on to research. Now, research is very multifaceted. We will focus on the research on law as well as facts, right? There are two aspects of research here. But given that you already read the moot problem, you know the basic facts. So we go on to researching on the applicable law or the applicable statutes on the moot, right? Say, for example, like I gave the example of some moot problem related to contract law, right? Or a breach of contract law. If it's domestic, if it's Indian, then you research on the Indian Contract Act, the Limitations Act, right? And then you go into the procedures. So you might open CPC and read which provisions are applicable. So in that case, I feel that once you're sort of thorough with the moot problem, you should definitely first make a list of all the statutes that are applicable. Because if it's an easy moot problem, if it's not as complicated, then maybe they've provided the statutes that are applicable, or there are not many for you to actually make a list. But then as in when you progress, you will find that a lot of moots also have multiple sort of, approaches and multiple disputes, which could range from contract to even criminal law. And so it varies. So it's always better to stay concise and to make a list of these documents, list of provisions, list of statutes. So if you're researching and you write, all right, section 22 of XYZ Act, it just feels that whenever you need to go back to that point, you just click on, say, for example, oh, sorry, that's my dog. Yeah, so you click on, you sort of go to that document and you read which sort of, act is applicable. So do that. Then once you're done with your documents, once you're done with the statutes, and once you're done with the provisions, then you also research more on the applicable case laws, right? Because case laws, as India being a common law country, if it's a national moot, case laws are absolutely important to understand how to sort of, prove a certain point. So once you know what the provisions applicable are, what the statutes applicable are, you go to various websites, you read commentaries, and you decide what case laws will be applicable, right? So you research, and I would suggest that wherever possible, use case laws of the topmost court. So if it's a civil court in some say high court in Delhi, it's always better to use either a judgment of the Delhi High Court of a higher bench or of the Supreme Court of India, because that also has binding value as compared to persuasive value that maybe lower court judgments have. So in that case, I feel that researching on statutes, provisions, and case laws then becomes the crux of your initial research that you conduct. And as I also said earlier, while reading the moot problem, when you sort of highlight different pointers for facts based on either side, you should do the same for your research. So say, for example, like the way I research is, when I'm researching, I do not know what point I'll come across that will favor either the petitioners or the respondents, in the present matter. So what I do is I create two Word documents side by side, right? And these Word documents will have petitioners on the on one heading and then respondents here. So as and when I keep finding relevant information, relevant case laws, relevant provisions that I feel will favor a certain side, I just keep copy pasting that to make a research bank, right? Because eventually you will get so much work that you have to put into different memos. It's always easier to segregate initially. So have different documents ready for both the sides and keep copy pasting different research, so that when you finally start making the memorial for, say, one side, you open just one document which already has all the research pertaining to that particular side. So that way it just becomes easier and more focused as compared to you sort of, while after having research, you again trying to segregate information because, oh, something doesn't concern this side, something isn't relevant anymore. So I feel all of this in essence is the sort of the first steps that you should take after you've read the moot problem and you just begin to research.
Thank you, Sambhav. We'll be keeping this webinar only in English because all the moot court competitions that happen in our country are all in English language. So it would be best if you start getting comfortable in the language as soon as possible or now itself. So, and that is the reason why we're focusing this, and we're going to keep this in just English language. We will hopefully, soon someday also probably do a webinar which will completely be in Hindi. But at the moment, because we know that, we know the kind of moot court competitions that exist out there and the number of them that do exist, they all are in English, which is why we're going to be focusing on English at the moment. So I hope you understand. Sambhav, thank you for that wonderful explanation. Sambhav, so tell us something about structuring the memorial and also framing issues and sub-issues.
Right. I think, again, that's the natural progression to once so till now, what we've done essentially is we've addressed how to tackle a moot problem, which is something that you get initially, and then how to research, because once you've read the facts, you also need to know the law that's applicable. Now, what happens when both of these aspects are covered and you have the initial knowledge to start working on the memo? Because mind you, till now, we were just researching. We were just sort of trying to gain more information and knowledge. So making a structure now, I feel, is the first step to actually start working on the memorial, right? Which is the theme for today's discussion. So quickly starting, I feel that structuring a memorial is quite important. And what do I mean by structuring? Now, say, for example, some moot problems already provide for a given, say, for example, 3-4 issues. Some moot problems provide, these are the issues that a mooter has to tackle. But some moot problems are a little more advanced and they do not sort of, provide the issues in the moot problem. However, you have to form the issues on your own. And that just becomes more tricky. So either way, what you should always do is once you're done with the research, you should always start by making a structure, right? What is the structure? Say, for example, in a moot problem or in a moot court competition, you have 4 issues, right? Or to make it easier, let's make it 2 issues, right? You have 2 issues, issue A and issue B. Now, if it's provided to you, perfect, your first step is done. But if it's not, that's when your moot problem reading skills will come into handy, right? Because you've already marked a lot of things, you will know what the bone of contention in this problem was, and then what you need to sort of, finally prove in court of law. So we formed our issues A and B, right? Obviously, after reading the moot problem and then reading the law, because then you'll understand, okay, the law provides X, Y, Z. However, the parties in the present case have not done this. So is this a contention? Is this something where, one of the parties went wrong? That becomes your issue. So your issue is essentially the bone of contention, the problem that occurred in the proposition, right? So what you do is you make a structure. Now, what is a structure? A structure essentially is like an index, a table of contents, right? When you read a book, you open the first page, it's table of contents. It shows you, okay, first this, second this, third this. So just like that, you make an index or a table of contents for a moot problem, which essentially is the structure. Issue 1 and issue 2 become your 2 broad headers. And then below that, you make sub-issues, right? Now, issue A being that, say, for example, issue A could be, given that we, sort of using the contract law example, issue A could simply be that, party XYZ breached the contract, right? Very simple. Now, issue A could be that party XYZ sort of failed to pay the amount. Then the second issue could be the second sub issue could be the party failed to deliver the products, right? Whatever the case may be, obviously, depending on the facts, your main issue will have multiple sub issues, because as detailed as your structure is, the easier it is for actually the person who will be scoring or marking your memo. Then, tick off those checkpoints, because mind you, whoever makes the moot problem or the organization that hosts the moot already has the pointers they're looking for in a moot or in a memo, right? So they will have that checklist. So the more detailed your memo is, the better it is. Also, always keep in mind this golden rule that regardless of what you'll actually argue in the oral rounds, your memo should cover everything, right? Your memo should not be, okay, these are not important, so let's leave that. Why? Because a lot of moots actually don't allow you to argue outside the memorial, right? So if you have only point A and point B, tomorrow if you find point C after having submitted the memo, you cannot argue that in court, or because the judges might just open a memo and say, okay, where is this in your memo? And then you will be stuck. So you should always have every possible contingency planned in case of drafting a memorial. So if you feel that something's not as important but could still be relevant, you maybe add a little portion of that, which could maybe give you a window to at least argue that in court, because you've addressed some of it in the memo. So make a structure. A structure acts as more of a blueprint for a memo. All you've done is just make headers and subheaders. So you have this structure, this blueprint ready for the memo. So that after that, when you actually start drafting the memo, all you have to do is just fill the headers with your research that you've already done till now, at least preliminary research. And then you will have your first draft of the memo ready. So these are steps that make it a little easier for you to draft a memo. After having research, just make a structure. Or make a table of contents, as we discussed, with headers, and you can have issues, you can have sub issues, and you can have sub issues, depending on how much research and how in depth your research is. So I think that is something that you need to do. And once you make the structure, whatever preliminary research you made, the different documents, one for this side, one for this side, having also made structures for both the sides, just fill those headers with your research, right? So if issue A has 3 subheads, you've made those subheads because you've already researched on that, right? So just pick up those paragraphs and those statements and just keep copy pasting them in under the structure. And you'll have your sort of a first draft there, and you then work on that. You don't have to continuously go through different documents and go from one document to another and just get sort of, confused all over. So that I've always felt is a very good way to go about starting drafting the memo.
Sambhav, there's a question here, which is that how can a person frame issues if none have been given?
Okay, now that question, there's no rule of thumb in terms of how you approach an issue, approach drafting an issue. It obviously depends on the moot problem. But at the same time, issues, because if they haven't provided issues to you, they will not, in all probability, like 99% of the times, moot problems will not make it difficult for you to find issues, right? So I'll tell you how to go about it if you haven't, right? Read the moot problem, do your preliminary research. The first 2 steps remain the same. Now, in the third step, when you read the moot problem and you know the applicable law, just like I mentioned before, there will definitely be certain complications in the moot problem, right? Because it's called the moot problem. There has to be a problem in it, right? So there definitely be some place or some event that happened which sort of led to this problem arising or this sort of dispute arising, right? We also, that also might be the cause of action for your moot problem or your moot, right? So whenever you feel that there is no actual issue being given to you in the moot problem itself, read the problem and highlight anything that you find could potentially be at fault, could potentially be problematic. Once you've highlighted, say for example, you've highlighted 4 to 5 instances, write that down, make it simpler. Look at those 4 or 5 instances, then again research, okay, can this happen? Like if somebody has sort of acted in a certain manner, is this bad in law or is this allowed, right? Most of the times you will find case laws where similar facts have occurred. Read those case laws, see whether that was a contention in that case. If that is perfect, you found your issue, right? So just like that, go to the moot problem, because moot problem is like the holy grail, right? Everything arises from those 5-6 sheets of paper. So read that, go through that, pick out or call out the bone of contention that you feel could be problematic, jot them down on a separate piece of paper, research on all of them independently, and you'll definitely come victorious, come out victorious with at least 2 to 3 pointers, which you can then build upon. Always keep your issues broad. Don't make your issues very narrow, because then you won't be able to make sub issues. So your issue should be broad, then your sub issues narrower, then your sub issues narrower, and that's how you sort of approach making the structure of a memo.
Thank you, Sambhav, for that great explanation. So Sambhav, what are the sources of research that you use generally?
Right. So again, we'll divide it into two. We have national moots, and then we have international moots. I think I also saw a question. Somebody asked, how do you approach international moots and everything? So I'll just take both of them side by side for the ease of understanding. So for national moots, we have certain set practices. We research on various articles, various case laws provided on portals such as SCC Online, Manupatra, even Lawctopus has a lot of articles. So you go through these websites, all these online resources, and especially for case law research. And also, mind you, a lot of articles will not be publicly available to you with just one Google search, right? And if it's a domestic court problem or a national moot, as we call it, then you will have to find High Court judgments, Supreme Court judgments, all of which might not be reported publicly, right? Maybe they're exclusively available on, of course, all of them are there on the Delhi High Court website or the Supreme Court website, but it's just easier to find a topic-wise case law on portals such as Manupatra, SCC Online, LexisNexis. So it's, and a lot of colleges also provide access to these portals. So it's always easier. If you don't, you can maybe, ask a friend who's done mooting or your college professors to provide you access, because I just felt that these resources really help you understand and really help you like cull out, because all you have to do is just write the topic, breach of contract, section 72, section whatever. And then you'll quickly see all the case laws that concern that particular provision or concern that particular topic. And then read, it's all about reading. Law as a profession is all about reading, right? So read the case law, see what fits your particular moot problem the best, and then just cull out those case laws, take out true copies of that, and create a database. Like from the very beginning, what we've been talking about, create databases, create indexes, be very organized, because in the end, all of this will help you in making a very concise, a very to the point memo. So this was national moots. Now for international moots, I think it depends, because while we have these portals which cover all the themes in India, for international moots, I've personally felt that there are different resources or portals for different topics, right? Now, so when I was researching for WIS, which is an international commercial arbitration moot, Kluwer Arbitration is a website that came handy to me, right? When I was researching for Jessup, which is a public international law moot, I always thought that websites such as the UN website or Westlaw or even Oxford publications, because they keep publishing a lot of material related to public international law. So that is something that came in handy, because moot problems in international law are quite specific in terms of they might not be as interdisciplinary. But at the same time, because public international law is so multifaceted, you can have human rights law coinciding with international criminal law and XYZ. So in that, I think there are different resources such as Kluwer, such as UN websites, such as Westlaw, and all of this really helps you. Now, these were online resources. Unfortunately, as of today, we are very restricted to researching online, because in a lot of places, access to libraries has been restricted because of COVID. But if you can get your hands on, please definitely do read commentaries, because commentaries are vital to understanding the perception of writers and jurists. In fact, I remember in the International Court of Justice, say, for example, which was the forum for Jessup, they do accept commentaries and, opinions of jurists as a source of law, right? So it's absolutely important, because a case law might say something, or some provision of some law might say something in very, very plain terms, but the interpretation of that and how it's applicable to the present circumstances in the contemporary world as we know it comes out from commentaries, comes out. So, common examples of whenever I think of criminal law, I will always turn to Ratanlal Dheeraj Lal, because I feel that that's like the essence of criminal law for me. and different sort of, we read these books. A lot of them are also part of the curriculum, but some you also might have to go specifically to research. So for international moots, there are different websites such as SCC, Manupatra for national moots. For international, you have different websites, and then I think all of it can also be found in books. So these three facets of resources are very important. Of course, other than this, you might get different resources from different friends. You can borrow from here and there, but I have always found these three to be quite helpful while conducting advanced research.
Sambhav, there's a question. What goes into a compendium?
Oh, actually, very good point. So compendium or compendia is essentially a compilation, right, of all the authorities that you've used. Right now, I'll make it. I'll break it down into what actually happens in a court or in a moot court. When you're arguing, a lot of mooters argue a lot of case laws, or we refer to a lot of commentaries. But at times, the judge might not be aware of that case law, right? Of course, because just like it happens in normal courts also, the advocate has to provide the judge with copies of case laws that they're relying on, right? So to provide ease to the judges of not having to constantly pass different judgments to the judge every time you refer to them, because, a moot court essentially is an academic activity. So it will have a lot of case laws, you'll be naming cases left and right. So in order to make it more understandable for the judges, you compile all of those case laws into one document, and you sort of, physical moots, it happened that you used to like sort of spiral bind all of these case laws. And that one spiral binding is called the compendium. The compendium is a collection of all case laws that you refer to, all authorities that you've cited, all commentaries. Of course, you can't compile all entire commentaries, but just like, the first page. So the way to do it is, sometimes a lot of judgments are also like, if I'm referring to K.S. Puttaswamy for a privacy law moot, now that's a 1,000-page judgment. I mean, all of them compile also sometimes. I cannot possibly attach the entire thing. So the way to do it is, take the first page of the judgment, take the last page of the judgment, and in the middle, the relevant pages that you're referring to. So when the judge sees it, they see the first page, then quickly go on to the relevant page you've cited and the last page. And you also highlight the exact point. So essentially, that's one judgment. Now, 10 of these judgments together then make a compendium. So it's a database for the judge to keep referring to. And you also flag the compendium. Like flag number 1 for the first judgment, then second judgment. So when you're arguing in oral rounds, you simply say, if your lordship may refer to flag number 2. And they quickly open flag number 2 in the compendium, and they have the case law right there. So compendium just make it easier for the judge to understand, and therefore you get a lot of more brownie points, if I may say so.
Thank you so much, Sambhav. That was very, very helpful. So the next question that I have for you is that, how do you connect your research with your facts?
Right. Very important, very, very important. I just feel that till now, just like, we've said, we've been doing things in different compartments, but essentially it's one moot court, right? So you've read the moot problem separately, you've researched separately, you've made the structure separately, but now is the time when you sort of compile everything, something that we just touched upon, how to sort of make your first draft. So having made your structure, initially we made a list of dates, we made a list of personalities. Now you also have your preliminary research on the case law, and you have your facts. The best way to now, the reason why we did everything step by step is because, everything comes together. So the way we do it is, you first read the fact. You read what the fact of the matter is, and then you read the law. And, both of them will be sort of, complementary to each other. In what sense? Essentially, in a court of law, you will be arguing law. You'll be saying how the other party either breached the law or how you have not breached the law, because you're arguing in the court of law. So read the law, see what the provision says, then go back to the moot problem, see whatever the problem says, which either favors your side or tries to prove that the other side is wrong, right? So if I'm trying to prove a breach of contract, right, I will use the necessary provision of contract law, which says, okay, breach of contract means XYZ. I will write that first. Then I will go ahead and read the moot problem and see where the facts mention that either the other side has breached the law or that I tried my best to make sure that the law is not breached, whatever facts support you, right? And then you also then bring your case laws, whatever you researched on, to write that there, in XYZ case, it was mentioned that this, just to prove your stance. So essentially, I feel that compiling the research and connecting it with facts is a practice where everything that you've done separately finally culminates together, and you use the law, you use the facts to coincide with the law and associate with them, and then you use case laws. Case laws always favor your side, right? Obviously, you will not use case law that favor the other side. So when you've given a precedent, right, to a court of law, then if it's a Supreme Court precedent and you're arguing in the High Court, or if you're arguing in the High Court of a division bench and you're giving a full bench judgment, it always has a binding value. So as soon as you provide a case law, it becomes the rule of law, as we call it, right? It becomes something that has to be followed. So which is why I feel that that is very important. And also, in talking memo specific, whenever you provide facts, which is absolutely essential, don't just fill your memo with law. You also have to show how that law is applicable in the present case, which is where your facts come into play. And every time you put a fact to sort of, complement the law, always refer to the facts, always refer to the page number and the paragraph number of the moot problem. Why? Because whoever's reading it for the first time, I think the golden rule of making the best memo is that whenever I read a memo, I shouldn't need to refer to the moot problem. I shouldn't need to refer to a separate case law online or anything. That should be self-sufficient. So if you've already written, the fact of the case, and then in the bracket, you write para number so-and-so of page number so-and-so of the moot proposition. It just makes it very self-sufficient, and I don't need to sort of, turn pages and go back to that proposition. I know that, you've provided enough evidence that this exists in the moot problem. So I just feel that this is one step which brings everything together, and it has to be done smartly. Don't use a lot of law, because then, they'll just say, but how is it applicable in your case? And you won't have an answer. Or don't use too much facts because you're arguing in a court of law. So they might just come and tell you that, but how can you prove this? What backing do you have in law? So just a very balanced way of doing that. And while it sounds a little complicated, it's very simple, because remember, till now you've done so much research on fact and law that it just becomes very mechanical for you in your mind. You know that this fact will fall here, this law will fall here, this case law, because you've done all the research. You have all the lists ready and everything. So just refer to them and put everything in the memo, and you have your first draft ready.
Thank you, Sambhav. I can see that there are a lot of questions and a lot of requests asking us to delve deeper into the drafting process as well as oral rounds. So we won't be doing that, because we're going to try to focus this session to only research aspect of it. But if drafting and oral rounds are something that you're interested in, then towards the end of this session, I will also be telling you a bit about the Moot course that Lawctopus offers. It's a 2-month-long course, and it also includes a moot court competition where you will be competing with a lot of other students. So, during the course, we teach you how to draft and how to footnote and how to basically go ahead and learn the court mannerisms. So, if that is something you're interested in, we'll talk about that towards the end of the session. But Sambhav, there's this question here from, I think, Prateek. So the question is, if the issues have already been provided in the moot proposition, but someone finds a relevant issue in the while researching, then can they add that too as a part of their pleadings or in the oral rounds?
That's a good question, but I think that depends more on the rules of the memo of the moot, which is why, as I mentioned, the first 2 documents that come out are the moot problem. In fact, before the problem also come out the rules of the moot to prepare you for, how you have to go about everything, and then comes the moot problem. So in that way, I feel that reading the rules is very important. If rules are not provided, contacting somebody from the OC or the organizing committee of the moot is very important, because sometimes the moot problem is self-sufficient. So maybe they write, these are the issues and no additional issues are required. That's a very clear statement, which means you cannot. But sometimes I've also seen a lot of moot problems which say that, additional issues may be drafted. So I think it's just a very black and white thing where either you can or you cannot, which is something that the moot organization will clarify. So that's something that you should always ask before you start working, because what if you found, you're right, what if somebody finds something that's very important, but it's not given in the moot problem? So it's always better to clarify first, as compared to, starting to work on it and then realizing that, oh, it's not allowed. So it just depends on the rules. But if you are allowed, suggestion is definitely go for it, because as I mentioned, the more information in the memo, the easier it is for you to argue. And like you mentioned, Suvarna, if say, for example, it's not mentioned in the memo, then can you argue? That is also something that depends on the organization. They might sometimes say that, you can argue outside the memo, which simply means your memo is just for the preliminary understanding of the organization. Obviously has to have everything, but there's no restriction on you to argue outside the memo. But sometimes they provide the rule that, you have to sort of restrict yourself to the confines of the memo, in which case it's all the more better to clarify what all can be included before actually starting to draft it.
Thank you, Sambhav. There's another question, Sambhav. Does it help to cite several case laws in a memorial, or what should be like the ideal number?
Okay, so there is no ideal number, but don't cite too many case laws, because I'll tell you why. See, every proposition, every contention that you're proving should ideally be sort of, accompanied by 2 to 3 case laws. Only because, I understand that people might think that, the more case laws, the better it is. But also understand that regardless of the quantity of the case laws, the nature or the quality of the case laws also matter a lot, right? Say, for example, again, I'll give the example of the forum. Say, for example, we're in the Delhi High Court, and you are citing 10 case laws, but all of them are of district courts or of the Delhi High Court, but of a lower bench. That will only persuade the judge so much, right? But as compared to that, if you have one case law which proves your point and is of the Supreme Court, that is ideally all you need, and you don't need additional case laws to sort of accompany that. That's one. So always keep in mind the forum for the the persuasive value as compared to the binding value. The second is, at times, because if the moot problem is drafted smartly, no one case law will directly prove your point, right? Because then what's the point of that if it's just like a copy paste of an actual case? I'll just use whatever arguments were used there and I'm done. I've proved my point. So every moot problem is open-ended. Every moot problem has points favoring both the sides. So it won't be as easy for you to sort of, just cite one case law which says exactly what you want to say and, oh, I'm done. So the number of case laws that you have to use also depends on how well that one case law has proved your point. Say, for example, you have to prove 3 points in that one head, and each case law proves one point each. So naturally, you have 3 case laws that should be included. But if you feel that one case law has sufficiently proved a point, don't unnecessarily add case laws just because you think it might look impressive. It doesn't. Also, because most of the memorials have a word limit or a page limit. So wasting that word limit by unnecessarily including case laws will, never sort of, give you any sort of advantage. So it's a very smart way of assessing, okay, has my point been proven? Is this case law of a higher court, which sort of, makes it more persuasive or binding on the court? So just sort of a combination of that should give you the answer of whether I've done enough or should I add more case laws.
Thank you, Sambhav. There's another question here, Sambhav. So at times from what I understand, what this question means is, at times in moot problems, there are statements like it is believed, and then, there's an entire sentence following that. So when a statement of this sort is given, so does this statement,
right? A lot of these students also do MUN, so they're the entire concept of belief and whatever comes into play. But when you're arguing as a lawyer in court, and you think about a statement, you also have to just understand what the relevance or bearing of that statement is, right? If the statement says it is believed that XYZ stabbed the other person, right? Now that is the bone of contention, because if they outrightly go and say, this person stabbed them, the case is finished, right? That's not. So sometimes moot problem drafters, if I may call them, that intentionally leave it a little vague for you to then interpret that. So if it is believed, imagine this: if it's a very important fact and they've written it's believed, that just gives either party the sort of the room to wiggle around and then prove that this fact supports them. So if it is believed and it favors me, I'll say, it's believed and it actually happened. The other side will say, okay, the moot problem specifically says it's believed, which means it's not an accepted fact, and therefore we cannot rely upon that. So it's a very two-way process where, because the moot problem will never favor one side dramatically, because then it's very unfair for the other side to participate. So statements like this, in all probability, are left open-ended and vague for a reason for either side to try to capitalize on them as best as they can.
Thank you so much, Sambhav. That was very helpful. So Sambhav, how do we go about footnoting?
Okay, footnoting is an absolutely essential part of mooting. And I've personally had brilliant people in my teams who excelled at footnoting. I also tried to footnote because I also feel that footnoting is something that's not restricted to memorials per se. I'll just also add that footnoting as a law student and as a student of law generally also helps you in life. Because if you not only making memos but writing articles, research papers, footnoting makes it much easier for either a judge in a moot court or a reader of your research paper in life to understand where you're coming from. Also, the role of footnotes is to actually give your memo substance. I can write anything in a memo, right? But unless it is accompanied by resources, it's accompanied by authorities, it will not mean much in a court of law. So therefore, I feel that footnoting is very important. Now, how do you make footnotes? Again, depends on the rules of the memo or the rules of the moot, because every moot has rules, and in those rules, there's a separate portion of memorials where they tell you exactly what all should be included in memos and what kind of footnoting is required. Some ask for blue book citations, some ask for MLA, APA. So it's just, and all of these, you don't have to know by heart. When you're making the memo, you should always refer to the rules, see exactly what kind of formatting they want, and then go about it. So for those who don't know, there are different kinds of formats that exist to footnote. What is a footnote? I have written a sentence. Say, for example, I've written a sentence that, the correct position in law is that privacy is a fundamental right. That's a sentence that I've written. Now I will footnote this, and in the footnote, I will write Justice K.S. Puttaswamy versus Union of India, because that's the case law in which it was accepted that right to privacy is a fundamental right. Right? Now, this footnote cannot just be left with Puttaswamy versus Union of India or the Puttaswamy case. You have to provide them all the information. So it will be the entire name of the case, the official name of the matter, then the citation, either an SCC citation or a Manupatra citation or whatever AIR citation. So it's just so that's one thing. The second thing is, once you've checked the format that's applicable, also make sure that whatever you can footnote, you do footnote, because footnotes are never counted. Most of the time are not counted in the word count for the memo or the page count or whatever. I mean, if it's a page count, then of course the entire pages are counted. But in a lot of moots where you have to restrict to a minimum number of words, they most usually restrict or refrain from including footnotes in that. So you can be a very liberal with footnoting. So footnotes usually are very to the point, just tell you what source you've got it from. So this is the case law, this is the citation. Sometimes some moots maybe they allow substantive footnoting, which means that you can footnote and write an actual note in the footnote, because you didn't want to include this information in the body of the text, but it's relevant for the context. So you write some 2-3 sentences. Again, make sure you know exactly what kind of footnoting the moot organization is expecting before you do it. Then also remember that footnoting should always be done side by side, right? You shouldn't leave footnoting to the end. That okay, abhi to I'm just drafting, and once my drafting is done, because imagine the kind of stress you will be in if you've made the entire memo, but there's no one single format. Footnoting, and then you going through each sentence again and thinking, oh, where did I take this from? Which case law I found this from? So remember, when we made these two documents for one side and for one side, when you're copy pasting these sentences or these authorities, always side by side, keep footnoting those as well. Not in format, because right now it's not that essential to you format it then and there, but always know where you're getting what from. If I've got this sentence, which book or which case law or which website I got this from. So that when you're copy pasting it, you copy paste the footnote with it in your memo, and then you start formatting it, as compared to you not knowing the footnoting at all. And then at the end, then going back to the sources and then seeing, okay, this was the book I got it from. So it's a side-by-side practice, and a lot of, it sounds again very elementary, but I've seen a lot of people leaving footnoting till the end and then struggling to find, oh, this is a perfect point, but I forgot where I got this point from. And they have to then they're forced to not use that point because every point has to have a footnote. Additionally, your footnotes should also, your just like I mentioned before, your moot problem facts should also be footnoted. So if you've written, XYZ sentence you've written, which you've picked out from the moot problem, which proves your point, you footnote that and write paragraph number this, page number this of the moot proposition. And try writing moot proposition instead of moot problem. It just sounds more formal. However, in different moots, there are different terminology that are used. In ways I remember it was statement of facts or something else. In Jessup, you refer to it most of the time as a compromise. So there are different wordings which you use to refer to the moot problem, but never either in the moot problem, either in the memo or in the oral rounds actually say that, it was written so and so in the moot problem. Never say it's a moot problem, because as of there, you are standing in a court of law. So you say statement of facts or the proposition, but never a problem. So that's that. And I think when it comes to formatting of footnotes, there are certain terms which need to be italicized, like, id or ibid or supra, all of which are footnoting terms. And all of these can be found online. If you just Google footnoting formats and what terms in footnotes mean, you know that ibid means I'm referring to the footnote just above mine. So if footnote number 10 is Puttaswamy and 11 is ibid, means 11 also means Puttaswamy, just the one above it. Id also means similar. Supra means something else. So these different kind of Latin terminologies or different terminologies have to be italicized. So all of this can be found online. What I'm trying to say is just make sure you pay attention to such details, because formatting also has a lot of marks for memorial. So if you have all the substance there, but you've missed out on this formatting, you might also actually miss out on marks. So checking the format of footnoting, always ask the OC what format of footnoting is applicable, italicize the footnotes, do proper formatting, proper italicization, what has to be bolded, what has to be underlined. And at the end, one golden rule of footnoting, always footnote side by side, as compared to leaving footnoting for the end.
Some of these are questions. If you're referring to, since you wish to refer or cite cases in a moot memorial, then does one have to go through all the entire judgments before citing them?
Not really, because it's humanly impossible for you, because you get a month or two to prepare a memorial, right? Maybe even lesser at times. If you've been allotted the moot, say for example, just 2 weeks before the memo submission, it's very difficult. So no, but at the same time, always know what the case law said, because again, we know that ratio decidendi is very different from what any observation a judge might pass. So the ratio of the moot of the judgment, is what's important. Now, a lot of times I've seen, in fact, while reading judgments, the judges refer to different case laws, judges observe something, but none of that has binding value as compared to the ratio of the case, what they've actually held at the end of the case, right? Or maybe somewhere in the middle. So in that case, just be sure that what you're citing holds substance. Either a judge has expressed their inclination to accept this fact, or they've observed something officially in the capacity of, in that particular matter, or it's actually what they held in that judgment. Because a judge might just write something in a judgment which you've seen and you've loved and you've copy pasted blindly. And maybe 2 paragraphs later, they've said, okay, but however, we do not agree with this position in law. So that judgment might actually be against you. So while you're not reading, it has to be very smart and selective reading of judgments, where you understand what exactly the case held, what exactly was the point of view of the judges, and whether this case law is relevant and sort of acceptable in the present matter. A lot of times also remember that a judgment might be brilliant. It might actually favor you, but unfortunately has been overruled by a bigger bench or a higher court. So that way, please also, I mean, there are different tools available on websites such as SCC and Manupatra, where you can just see whether this judgment is still good in law or has it been overruled. But all I'm trying to say is, which I think is what the person also wanted to ask, don't blindly trust a judgment. Make sure you do your due diligence, see whether the facts are actually what the court held, also whether the judgment is still good in law and all of that. But no, you don't have to read the entire judgment unless it's a small judgment and you can read that. If you can read the entire judgment, brilliant. But sometimes it's just not practical enough for you to do that. So then keep these pointers in mind.
Thank you, Sambhav. There's another question. Can we mention a judgment given by the same bench?
Yes, you can. As I mentioned, you can mention a judgment based of a lower bench as well, of a lower court as well. But remember that they are not binding, right? Because see, for example, even if you've used the judgment of the same bench, most of the time what happens is the court accepts it as a good position in law. But at the same time, it can be challenged by the other side simply because, it's not written in law and it's not valid here because we can contest it. So it's always better to choose a higher bench's judgment or a higher court's judgment, because then the other side can't question that position in law. But yes, I mean, to answer your question, yes, by all means, you can use the same bench or the lower bench, but just remember that that will not have as much value, or it won't have binding value at all, but it will be persuasive, to say the least. So, I mean, that is something that you can do, but maybe try to use of a bigger bench is what I'm saying.
Thank you, Sambhav. So, Sambhav, what are the other procedural requirements while you're drafting a memorial?
Right. I think generally also, now that we've addressed every facet of how to sort of approach it, begin it, how to draft, compile, there are some requirements that I feel are also something very important, and you should keep them in mind. Again, going back to these rules, because I just feel that whatever is provided to you should be utilized as much as it can. So the rules of the memorial and the moot problem are the two documents that you've been given from the organization, right? So most of the times the rules themselves mention things like what all should be included in the structure of the memo. There are two parts to a memo, for those who don't know. One is the procedural part of it, and one is the substantive. Till now, we were discussing the substantive part of it, the arguments, the structure, whatever contentions in law they're trying to prove or disprove. But at the same time, there is a procedural part of mooting, of memo making as well, right? Which includes like the cover page, the table of contents, the index of authority. So let's just sort of address a few of these briefly, so that you have a fair idea of how to go about them. So a cover page is essential. Why? Because it just is the first thing you see in a memorial. And there are certain requirements of a cover page. Again, a moot might or might not tell you what exactly is required, but there are certain rules. Like, say, for example, if you're representing the petitioner's side or the applicants or the claimants, in national moots, the cover page that's usually acceptable is blue in color. For respondents, it's red in color, right? Now, what all should a cover page include? It should have the case title, your team code, the team that you're representing must have been given a code, the forum that you are appearing before, Supreme Court, High Court, District Court, any sort of tribunal, then the provision of law under which you're approaching them. Article 32 could be Article 226, could be whatever, right? So that then as I mentioned, the case title, which means also the names of the parties. So Mr. X, which could be the applicant, versus Mr. Y, which could be the respondent. And then at the end, you also write memorial for the petitioner or memorial for the respondent. So that, in a sense, is your cover page. Never include the logos of your colleges or some personal information on the cover page. I've seen a lot of people do that. Some people include logos of either their college. So I'll add IP University's logo maybe, or the logo of the other college which is organizing the moot, right? Don't do either, because think of yourself as somebody making a document which will go in court, right? You don't have logos there. So try to avoid all that. Just keep it very plain and simple. And the table of contents, thankfully, is something that we've discussed till now. So it's just that index that you made, the structure, that is your table of contents. Every heading essentially comes in the table of contents. So issue, sub-issue, sub-sub-issue, sub-sub-sub-issue, whatever kind of sort of structure you've made is the table of contents. Then your index of authority is very important. Again, this is something that is asked for in memos usually. Index of authority is just whatever authorities you've cited is something that you have to also then specify initially, right? So before your memo actually starts, the substantive portion of it starts, you make a table of or a list of a table of contents. No, table of contents is done. You make an index of authorities. I'm sorry. So index of authorities, all the case laws that you've cited, all the commentaries that you referred to, all the provisions and the statutes you've referred to, you include them right in the beginning so that anybody can see, okay, these are the case laws they've cited, or these are the sort of statutes they refer to. So that is an index of authorities. Then you also include something called as a list of abbreviations, because again, you have to save as much space and as many words you can in a memorial. So sometimes you end up abbreviating a lot of things, all of which has to be provided in the beginning of the memo, because I don't know what some symbol of yours means unless you tell me initially. So even small things like, in X versus Y, we write V dot, or maybe somebody writes VS dot. So that's an abbreviation for versus. So you include that in the list of abbreviations. You sometimes might want to write and as the symbol and not A and D. So you write that. So just like that, you make a list of all the abbreviations that you've used. Maybe sometimes, I remember in my first moot, I had a character, which was known as Rohan Faliman or something, the character. So I just abbreviated the person's name to RF because that was reappearing so many times. It was taking so much space. I just made that RF. So in the list of abbreviations, I write RF and I write the person's name. So you can abbreviate anything and everything which can be abbreviated. Just make sure you mention it first. And other than that, you have a summary of arguments that you provide initially. Once you're done with the entire memo, it's easier for you to make a summary. So just like a small summation of how you sort of approached each argument or each issue. So if you have 4 issues, you'll have like small 4 paragraphs, summary for issue 1, summary for issue 2, 3, and 4, and just sort of summarize what it is that you're approaching and what it is that you're trying to prove. That's it. And then you write a summary, a statement of facts as well. And some moots also ask you to summarize the facts in 1 page. Now it's a 6-page moot problem. How will you summarize that into 1 page? That is why initially you read the moot problem carefully. You highlighted all the important points, and you have a list of dates. You have a list of organizations and entities and personalities. So you have all the database, just cull out the important parts of it and include that in a very structured form, and you have a statement of facts. Then a lot of moots also require statement of jurisdiction, which essentially is what provision of law you are sort of, approaching the court under. Why does the court have jurisdiction? So you write that statement of jurisdiction, and that essentially is what is usually required in the procedural form. But sometimes a moot may require more, which is something you need to sort of, clarify initially. And the last thing I would say is also please keep in mind the page limit, because procedural might not be counted in page limits, substantive is, but it forms a part of the format. So never exceed page limits. Also, if say, for example, the page limit is 40, try to reach as close to 40 as you can. Don't submit a 20-page memo because, maybe they might be expecting more, but don't cross 40 in any way, because most of the times they provided for a marking criteria as well. Like for every additional page, we'll cut 0.5 marks or something. So page limit is something that should be kept in mind. But yeah, that in a sense, I think covers the procedural aspect of memorial making.
Thank you, Sambhav. So, Sambhav, when is the right time to start mooting, and how has it helped you as a law student?
I think the right time to start mooting, I'll be very biased when I answer this. The right time to start mooting is as soon as you set foot in a law school. I did that because I remember the first induction round that we had. I just signed up for it, not knowing what mooting is. I am somebody who's just graduated from school. I don't know anything about the law, but I just started because you have to start sometime, right? If you are interested in mooting. See, mooting is not compulsory. Some people don't even like mooting, and that's completely fine. But for those who are, and I'm assuming the ones who are seeing this are interested in mooting, you should sign up at the earliest. Never be afraid. It might seem daunting, but it's not. some people do get overwhelmed with the idea of arguing before judges as an actual court. But understand that the organizers are also smart. They're also perceptive of the fact that you are first timers. So I remember my first year moot problem. Now, if I read it, was a child's play. It was a 2-page moot problem. But at that time, it felt very difficult to me, right? Because it's the first time. So they make moot problems which will cater to the audience. And it's only, and you know, you're bound to maybe, it's probable that you'll fail sometimes, you will sometimes, but trust me, the amount of experience only has led me to maybe, you know, perform a little better in the future events. Had I not done my first MUN in the first year, I would not have got the confidence or the encouragement to do it in the second year and the third year and then the fourth year. So I tell all my friends and everybody that I sort of study with that, you know, my law school was mooting for me. I mean, if I was mooting every semester, like one moot per semester, either intras or externals, I don't know how to do law school without mooting. So for me, again, you know, which is why I said mine will be a biased answer, start mooting at the earliest, because the moment you start, you might face some hindrances, but you'll also overcome them as quickly as you can, as compared to starting in the fourth year and expecting that, you know, you will do wonders. You might be a naturally, like, you know, brilliant person at it, then kudos to you. But people like me actually take some time to understand how to do mooting. So start in the first year, don't get overwhelmed, talk to people who've done moots, talk to your seniors, and they'll tell you actually how to approach it. Just like this webinar, we're sort of trying to help you understand and approach Lawctopus's course is something, you know, you will actually benefit from in understanding what a first timer should do when it comes to mooting. So, but yes, I would say start at the earliest and just sort of keep progressing.
Thank you so much. Thank you so much, Sambhav. So I can still see that there are a lot of questions here related to drafting and oral rounds. And I will address some of these questions now, just after probably 2 to 3 minutes. I'll also be telling you more about the course that we have here at Lawctopus. Basically, we're trying to teach you mooting in and out, you know, the ins and outs of mooting. And we're trying to teach you from the very basics, like from ground up. That's the whole idea that we have here at Lawctopus. And the course has helped a lot of students do really well in mooting. So I'll be telling you a bit more about that. But before that, thank you so much, Sambhav, for this wonderful session. It's always a pleasure being a part of your sessions, because I also get to learn so much. But thank you so much for this very insightful session. And hopefully we'll get to do this again very, very soon.
Definitely. Thank you, Savarna. Thanks to Lawctopus, and thank you for everybody for being here. I think you've already taken the first step by attending these webinars and these courses, and all the best to all of you. And I hope to talk to all of you again soon sometime.
Thank you so much, Sambhav. Thank you so much. See you soon. Bye-bye. Okay, guys. So as I was already telling you, and as we were already discussing, I would like to take you through the course that we have at Lawctopus about mooting, basically. So the idea here is that we wish to help you out. We want to, you know, help you out in whatever way possible. This webinar was also a way to sort of give you the basics, but you know, it's impossible to teach you mooting, the entire concept of mooting, all the basics, fundamentals, as well as advanced aspects of mooting in just a matter of an hour or 1.5 hours or 2 hours for that matter. It takes time, it takes persistence, and so what we do here is that we have several classes. We have a 2-month long course that we have lined up for you all. And also, please fill up this form that we have here. I put it in the chat box. This is an expression of interest form as well as a feedback form, so that we know whether mooting is something you're really interested in, and whether you enjoyed this webinar, if you know this was something that you liked. So please do fill it as well. And I'll share my screen with you, and I'll just show you, I'll just give you like a bit of an idea about the course. Is my screen visible to all of you? Can you all see this? Okay, I can actually, there's this one question that I can see. It's from Darshan, and I have been seeing this question for a bit. But you know, as I told you, we weren't really addressing questions about oral rounds, but I'll give you an answer to this. If you do not know, you know, a certain question that the judge has asked you, then you can just tell them that there are two ways to go about it. You can either say that I plead ignorance on this matter, and your lordship, I'll get back to you, or your ladyship, I'll get back to you. I'll look into this and I'll get back to you with an answer. Or you don't say I plead ignorance, and you just say, your lordship, I'm not aware of this, or your ladyship, I'm not aware of this, and I will get back to you with an answer once I look into it, or once I do a little bit of research. But I'm sorry, but my apologies, I'm not aware of this at the moment. The idea is to be honest, because see, if you start taking them, if you start taking them for a ride, they'll know that you don't know the answer and you're trying to mislead them, and that will not go down well with them. A lot of judges during these moot court competitions are very they're strict, they're also reserved, and they're okay, Mehak, basically just tell them that your lordship or your ladyship, I'm not aware of this. Please give me a minute, or please give me some time, and I will definitely get back to you with an answer to this. Just tell them that you don't know that. So this basically shows you don't know the answer, but you've admitted to it. You've not misled them. You've not given a wrong answer or anything. Just let them know that your lordship or your ladyship, please, my sincere apologies. I'm not aware of this at the moment, but I will definitely look into it and get back to you. Yeah, something on these lines. I understand that, because oral rounds are difficult. I absolutely understand that. For me also, for the longest time, I had the most difficult thing for me to do were these oral rounds. Drafting, because, there's generally a team, and at times, you're by yourself, you still have 2 months. So you still, you're able to go through it. But speaking, of course, that's a different ball game altogether. There are court mannerisms involved. Oral argumentation in itself is an art. So what we here are trying to do is we'll be teaching you how to research, we'll be teaching you how to draft, and we'll be teaching you about oral arguments. So first and foremost, what are the benefits of mooting? Sambhav has already delved into some of them, but we'll just give you a bit more. It will help you improve your research skills, your writing and argumentation skills, presentation, teamwork. A lot of law firms these days hire people who have been excellent mooters. A lot of internships are also offered to students who've been excellent mooters. So mooting really adds a lot of value to your CV. Please don't forget that. Mooting helps a lot. Sambhav is a very well decorated mooter, which is also the reason why he has had internships at some of the best law firms out there. So please do understand that mooting is something that it's exclusive to law schools, of course, and it will really help you in your near future. So it's important, and of course, it in itself is a journey towards self-development and growth, and it will definitely help you. An A to E guide, basically, it builds on your analytical skills, on your boldness. You feel confident. On court mannerisms and communication skills, of course, and drafting and research skills, and of course, an experience in lawyering. This will be your first experience in lawyering. After this, when you actually go to a real courtroom, it will not seem that difficult to you. So why this course? We understand that, and this art of mooting is an essential step towards having a successful professional future. We get it. We understand that, becoming a mooter will ultimately set you apart from other students, and it will put you on a path to becoming a good lawyer, which is the reason why we started this course. So yes, there are, we'll be teaching you fundamental and advanced aspects of mooting. We'll be teaching you researching and drafting a memorial. We'll also be teaching you about oral arguments, speaking with confidence, thinking on your feet, court mannerisms. We'll also be teaching you citation techniques, because I saw that, there were questions about citation, and there always are. Students who wish to moot, who've just started mooting, they always have questions about citation. So that's also going to be taught during this course. So it's a completely online course. We'll have 5 live sessions, and the course also includes a competition. So we'll first teach you how to moot, and then ultimately we'll also be having a competition where all the other people who've also enrolled for the course, you will be competing against all of them. And we'll be having an oral round for that as well. So we'll be having 2 assignments. One will be submitting a memorial. We'll be giving you a problem. You'll be making a memorial. After, of course, we teach you how to do that. And then after that, we'll also be teaching you how to go about oral rounds, and then you will have an oral round as well based on the memorial that you would have made. So yeah, the one of the highlights of this course is, of course, that we give you feedback. You will get a personal feedback from an experienced mooter, who is Atisha in our case. So she's completed her LLM from University of Nottingham. She's been an expert mooter, an experienced mooter for a very long time now. So she'll be giving you a written feedback, and during your oral rounds you will be receiving an oral feedback which will be live, and she'll give it to you right in front of you, through Zoom. We'll be doing like a video call. So you will be giving your oral rounds via Zoom, and she'll also give you your feedback then and there. So it's a very personalized process. We try to keep this as personal as possible. We want to create a healthy learning environment, because we understand that law school in itself gets very hectic, and we don't want to put any extra pressure on you. So our idea is just to create a very healthy environment here, and to be able to support you whenever you need and in whatever way you need it. Atisha is going to be your faculty. She, as I told you, she completed her graduation from NUALS in 2018. Then she completed her LLM from University of Nottingham. She's won multiple national and international moots. So yeah, as I already told you, we'll be giving you personal feedback. There's also a module in this course which is basically about building a mooting culture, because I know a lot of you might be in new universities, universities where there aren't existing moot court societies or something of that sort. But to help you understand that how you can build your own moot court society, and we've had great success with this as well. We've had students who did this course and went for national moots. We have a student who went for an international moot after doing this course, and he did exceptionally well. We have students who created their own mooting society in their college because they didn't have any. So we just want to we want to build a community. We want to help you build on your knowledge. And so of course there are a couple of add-on benefits to this course as well. If you do exceptionally well, if you do really well in this course, we can definitely help you get internship opportunities at partner organizations. You will always have an opportunity to publish for Lawctopus's own journal. We have an ISSN number as well. It's called Academic. The journal is called Academic. You can publish your articles there. You'll also have a chance to be a peer mentor for future batches. This is a paid position. It's we are currently also running something of this sort at the moment. It's called the Campus Leaders Program. It's more of a marketing internship, but it's a paid one, and you can definitely apply for it if you do this course. And then, of course, we also have CV advice and career counseling, which we do very frequently. We do this once in 2 months for sure. We do like a proper career workshop, helping you how to make your CV, cover letters, career counseling, LinkedIn profile building, because that too is really important. So if mooting is something that you're really interested in, then please do check out the course. And if you use this coupon that we're offering at the moment, which is Moot W10, if you use it till January 24th, which is Monday, today is Saturday. So if you use it till Monday, you will receive a 10% waiver. This course is currently this course is currently for $3,800, but if you use the 10% waiver, then you can definitely then you will have to pay a lot less as compared to that. So if this is something that you're genuinely interested in, then please do check the course out. So classes are generally in the evenings. They'll be on a weekday. Classes will be from like 6 to 7:30. They'll be 1.5 hour long classes. Can someone who's just taken it? Of course, we've had students who've been in school and they've done this course. So the course is starting from 10th Feb. It's going to be a 2-month long course. So from 10th Feb to 10th April. I'll also put the coupon code here, so that in case you decide to do the course, please use the coupon code. Don't pay the complete amount. If you can get some amount off, then please do that. I've personally, I've handled this course for 6 months. When I just joined Lawctopus, I'd started with this course because I also have judged moots in the past. So that is the reason why I was made a part of the course. I no longer, of course, am doing the same course, although I occasionally, do go and judge oral rounds and everything. But yes, the course since I've handled it, I know how it works, and it's a very smooth sailing course. You have one live class a week, and it's a 1.5 hour long class. And you have 5 live sessions, you have oral rounds as well. Varsha, the timings are basically in the evening. So when there's a class, it will be from 6 to 7:30 or 7 to 8:30. It depends on the faculty, and it also depends on the batch. But generally, these are the timings. They'll always be in the evening. When you have oral rounds, they'll be on Sundays. So you'll have a proper. Muskan, can you put your question again? I'm not sure what you had asked. From this course, just give me. Okay. Can we also learn legal? Yes, yes. Legal research will also be a part of this course. The first class that we have, the first live session that we have, is on researching for a moot problem and researching into it and just how to go about that process. We also have video lectures on how to research on SCC and how to research on Manupatra. So, Khushi, what's your question? Just give me a second. How can we connect with the guest speaker on social media? I'm not sure. I think he's on LinkedIn. You can reach out to him on LinkedIn. I'm not sure how active he is on social media, because I know he was really inactive on Facebook and Instagram. So he's not there at all. I think Instagram, his account has been deactivated or something. He is on LinkedIn. You can reach out to him. I'm not. I don't think he's much of a social media person. Is it necessary to fill the form if not interested in the course? You can fill the form because it still has a feedback option, so you can definitely fill it. If you don't wish to fill the form, that's also absolutely fine. No, Shobika, there's no certificate for this webinar, but there will be a certificate for the course. So if you complete the course, if you do it well, then you will get a merit certificate as well, which will be signed by and which will be basically affirmed by the CEO of Lawctopus, Mr. Tanuj Kalia. And of course, there'll be a certificate of completion. If you do a decent job, but not an exceptional job, then you'll get a certificate of completion for sure. Can you provide is there any course for law subjects? Yes. So Varshika will also be telling you about another course that we have here, which is basically a legal research and writing course. It's all about legal research and all about writing. In the Moot course, there's only like a part of the, the first session, and the first module is about researching, because the focus is only on researching for Moot court competitions and for Moot memorials. But Varshika will be giving you more of an idea about, how to just, her course is about legal research in general, which is something that you'll require if you intern. Varshika, are you there?
Hi, Suvarna. Yes, I'm here. Could you please provide me screen sharing access?
Yes. Akash, so yes, so the session regarding mooting is complete, and just regarding mooting, and if the course is something that you're interested in, please do check out the course. I put it in the chat box again. And if you do decide to purchase the course, please do use the coupon code. Do not pay the complete amount. And yeah, that's about it. Varshika will also take you through the legal research and writing course now. You can also check this out. Varshika, please.
Yeah, thank you, Suvarna. Hello, everyone. I hope you had a nice session on mooting. So just to quickly take you through legal research and writing course, because this is also one of the very important aspects of mooting itself. You can't possibly enter a moot competition without having requisite research and writing skills. So let me just take you through one of these courses that we have. And yeah, we'll just get right into it. As Suvarna has already mentioned, that the whole purpose behind having these courses in the first place is to have students have an informed and inspired career. Because when I entered law school, I had no idea what research was, or what mooting was, or what debating was, to be very honest. Because I come from a small town. In our schools, there was no culture of debating, mooting, or anything of that sort. So to have a basic idea about at least when you enter law school, because all of us are not very, comfortable talking to our seniors right as we enter law school. So if there is some other external source which can give us this information, it is always very, very useful, which is why we have all these courses, to be honest. Now, coming to research and writing course particularly, as Suvarna has mentioned, and I am going to tell you this explicitly, that research and writing is something that every law student, no matter what profession they choose, will have to go through in at some point in their career, in their law school, or any point. You pick any I'll say profession, and you cannot tell me one profession which doesn't require any kind of research or writing skill, and I'll tell you where it does. So this is one of the most basic and important skill you need to have as a law student. Okay, these are core legal skills which you have to have no matter what profession you intend to choose at later point. Now, what does this particular course help you do? First of all, become a better thinker, better researcher, and better writer. And the whole approach is designed in a way that will always aid you not only to finally write a paper, but also to think like a lawyer. It is important to have that understanding as to how to think, how to think properly or in a right way, which will propel you into becoming a better lawyer ultimately. Now, how to write a legal research paper from start to finish. And for this, we have an entire process and system of assignments, which I'll just discuss in a minute. And that is one of the feature that completely stands out in this course, because it's literally holding hands, taking you through the entire process of writing a research paper. So of course, if we are holding hands and taking you through that entire process, through giving you feedback at every step of the way, whether you are a first year student or an experienced faculty who might need a little brush up on their research and writing skills, it's definitely going to help you. And these are, very young individuals later on who end up publishing papers, right? Like exactly the paper that they're working on as an assignment for this particular course, they end up publishing it. So ultimately, if you put in sincere work and decent amount of work, you will end up getting a paper published out of this course only. So finally, of course, to introduce students to career possibilities, we do have an entire session which we devote to this and discuss various possibilities, because career possibility as a researcher and writer is not something that many law students want to pursue as their first choice. But a lot of avenues are opening up these days, and that's what we discussed in this session. Now, course material. There are reading resources, extensive reading resources, which are designed by brilliant faculties. There are self-assessment exercises, recorded video lectures, discussion portal is open for you to have peer discussions. Then there is one very important aspect, as I just told you, about compulsory assignments. And most importantly, feedback at every step. Okay, there are in total almost nine sessions, but there are 5 live lectures on all the reading material, and then there are assignment lectures, which in itself is an academic class. We also have a lot of activities during these assignment sessions, which help you interact with your peers, as well as get some kind of practical, things done, practical bits of research and writing, which you actually get to do in this live class itself. Of course, we have a lot of webinars which we share with you as part of this course. To quickly introduce the faculty who have developed this course, because it is important that you understand where this knowledge and where this entire material is coming from. So Abhairaj Nayak is the lead faculty for the course. He has also recorded video lectures. And let me tell you, you can go to YouTube and search his lectures. One of his lectures that we shared on YouTube, it's on small templates question. It's like 5-6 minutes videos. You can go through 1 or 2 of them and you'll see he is such an exceptional speaker and definitely a brilliant writer. I mean, I'm no one to comment on that, but still, he is such an exceptional speaker that if you go through his video lectures, you'll understand what kind of person he is, and especially what kind of professional he is. So he is the one who has designed this entire course, and I can vouch for it that it is definitely helpful. And of course, the reading material is designed by Shratanjay Bhardwaj, another exceptional lawyer, but very, very, very brilliant scholar. You can access his readings. He keeps sharing. He's very active on LinkedIn. You can connect with him and go through his write-ups and the articles that he publishes. He's again brilliant. And of course, the qualifications you can see on the screen. There are other faculty members, Anandita and Pooja. They have created modules on citations and video lectures. Citations is one of the most, tricky part of entire research and writing, especially for students who are just starting off. They don't understand the idea of citations, referencing, footnotes and notes, etc. So for that, we have simplified it for you, and we have an entire module as well as, I think, an hour-long videos on citation. So we'll talk about that. And there is Professor Sambhav Sharma. She has designed the entire system of assignments that you can go. That is one of the best part of this course, because I mean, everything is exceptional, but this is something that I personally stand by, because as I told you, we take you through the entire process of writing one entire research paper. And the most important thing in research and writing is to have the approach right. And through this system of assignment, as well as feedback at every step of the way, we ensure that you are not faltering in your approach. And that's most important. Ultimately, you will write papers once you practice. It's not something that comes to you overnight, or it's not something that you can produce overnight. It takes time, effort, lots of skill development, and a lot of patience. Sometimes one research paper can take 6 months, 8 months, a year, 2 years, and whatnot. So for that, this entire assignment system is in place to help you get the approach right. And this has been designed by Professor Anupama. And after that, I'll be taking all the live classes for you. And that's about it. Now, this compulsory assignment that I've been talking about, this is something that I want to highlight, as I've already told you that this is one of the best features of the course. Here we give you one assignment to write an entire paper, which of course you can take back and publish anywhere you like, but we do have an option to get it published at academic also, which Suvarna has already mentioned. Now, this is a three-step process. First step is to submit a topic and question. Second is to submit rough draft, structure and literature review. And of course, finally, you submit the final paper. But after each submission step, we call them as mini assignments. So after each step, you will be required to submit it on time, but you will also receive a detailed feedback on your work only. And once you receive this feedback, you'll know where you have gone wrong, where is it that you made mistake in your approach, or where was your approach incorrect or inefficient or inadequate. Okay. So which is why we'll give you feedback at each of this mini assignment. It's a 3-step submission process, and you'll get feedback at each step. And of course, it'll be a detailed feedback, so it helps you get the approach right. And then we also give you a chance to resubmit your papers after making these corrections. So that's why this is a very tedious process, I understand, but at the same time, ultimately, you are not only getting your approach right to write an assignment or write a research paper, but you're also writing a research paper. So there is some product that is coming to you at the end, which you can publish. And of course, we help you through an entire system that is there in place, and all of that can be discussed later. Add-on benefits is something that Suvarna has already mentioned. Same add-on benefits also exist for this course. You get internship opportunities, opportunity to publish at academic, become a peer mentor or campus counselor. And finally, of course, we do have CV advice and career counseling in place. Achievements of previous batches, people have published their papers. And if you have this question that I'm just starting off with research and writing, or I have no idea about research and writing, then of course, this course is actually designed for you guys. So don't worry about it. People who just started off with this course have gotten published at really good places and have very many other achievements. So that's why don't worry about it. That can be taken up. That's the whole reason why we have, this particular course in place.
Just Thank you so much, Varshika. Muskan, so the answer to your question is very simple. Moot course also teaches you how to research. The first module of the Moot course and the first live session of the Moot course will simply teach you how to research. That will not teach you drafting. This course, the legal research and writing course, is something which is only based on research, and it will teach you research in order for you to basically be able to write a research paper, and also probably do well during internship. So the purpose of the two courses is very different. Of course, in both the places you will be learning how to research, but in the Moot course you will be learning other aspects of mooting as well. Legal research and writing is solely about research. Okay. Any other queries? If there's any question that any of you, okay, so the legal research course is, I think, for 4,800 rupees, right, Varshika?
Yeah.
So the legal research and writing course is for 4,800 rupees. You can use Varshika?
Yeah, it is 4,800.
Yeah, 4,800. Yes, you can use the coupon code research10 to receive a 10% waiver for this course. So there are two different codes. For the Moot one, it's Moot W10, and for this for legal research, it's research 10. So ma'am, we'll be able to do a paper presentation and publish articles and take part in the Moot. No, these are two different courses. So Abhirami, if you wish to do a paper presentation, then that's a part of the legal research course. And if you wish to moot and participate in a moot court competition, then that's a part of the moot court the Moot course. You can do both the courses, but we wouldn't recommend you doing both the courses simultaneously, because both are 2-month long courses, and both are there will be a lot
Very
of classes.
intense.
There'll be both will be a little intense. So we wouldn't suggest you to do both of them together. You can choose one and go ahead with one, and then you can decide to do the second one. Legal research and writing especially is very intense. Varshika teaches the course, so she knows this. It's quite a process. Moot is slightly less intense comparatively, so you can do one course at the moment, and then you can go ahead with it. Through which group will we get updates? If you decide to join the course, then anyway you will eventually receive email updates and all. If you haven't joined the course, then that's a different issue. Then I don't think you'll need updates anyway. But yeah, if you do join the course, within the next 3 days, you will receive an email. We'll be in touch with you. We'll stay in touch. So basically, yeah. So as I was telling you, one important thing, these courses have live sessions. But the live sessions, in case you do miss out a live session, that's absolutely fine. We record all our live sessions and we upload it for you, so that you can, in case you are a part of the course, you are doing it, and you do by chance miss out on a session, so that you can watch it later. So we'll always give you this option of being able to watch the session later. So don't worry about missing out on a session or not being able to attend all the live sessions. Okay, so if I've sent you the WhatsApp group link, I'll be sending you one message which will combine all the information that we wanted to give you until now. But thank you so very much for attending this session. There will be no certificate for this webinar. I think we had mentioned this in the Lawctopus post itself. But yes, if you do join the course, there'll be certificates, there'll be a lot of perks there. But yes, hopefully we'll get to see a lot of you very soon in our courses, and hopefully we'll get to interact with you very soon as well. Thank you, Varsha. Really nice to speak to you too. Thank you so much for all the wonderful questions, for all for interacting so much with us, because it really helps us understand that whether you enjoyed the webinar or not as well. So thank you so much for attending this. And any permanent group of Lawctopus updates, you can follow us on social media. So we keep updating it. You can follow us on Instagram. If you're on Instagram, just type Lawctopus, and we have an account there, and you can follow us. We put out a lot of information over there, a lot of news updates and all. So please do, if you wish to receive more updates, you can follow us on Instagram. Thank you guys. Thank you so much. We'll end this session. Okay. Bye-bye, guys. Hopefully we'll see a lot of you soon. Okay. Bye.
Bye, everyone. Have a nice day.